This is Professor Wes Porter about criminal law, specifically the parts of crimes. Talk a little bit more about causation here, and including some popular cases that are read as they demonstrate causation. So one thing to keep in mind with causation, it's really an issue spotter thing, and it's most oftentimes result crimes. We're talking about an act that happens, some type of actus reus, some type of willed muscular movement that brings about the social harm, brings about the result that society was trying to legislate against when they brought up this penal code provision. So a lot of times it's homicide. That's the most popular result crime. Don't do anything that brings about the death of another human being. And really we're looking at when the harm was caused, when the act was taken, and does it fairly relate to the result, the social harm that was brought about. So it's kind of a timeline type thing, and it's also a correlation type thing. And I want you to understand that causation is principally a defense argument. We're using causation to eliminate culpability. Yes, I represent the defendant. Yes, the defendant did this or committed this act, but it's not fair to hold them culpable for the result, for the social harm that came about, or it's not fair because there was some type of intervening circumstances, or maybe they weren't even the but-for causation. They did an act, the person ended up with this result, like death, but they wouldn't have died but for these actions. So there's these two parts that we've talked about with causation, of but-for causation and proximate cause, and they both provide arguments for the defense to essentially eliminate culpability. So for the issue spotting aspect of this, we're looking for result crimes. We're attuned when we're thinking of homicide as the most popular result crime. We're looking at some distance and some other facts and time between the actus reus in the case, what did the defendant wake up in the morning and do, and the social harm or result that comes about. And again, here are the two. Causation, in fact, is but for. We know some of these terms from our study in torts. And proximate cause is just when we're doing some a fairness analysis. So it lends itself for your law students, lends itself for making arguments on both sides. It is inherently unfair to hold this defendant responsible for this harm that is too remote, that has other intervening causes in between. Or from the prosecution's perspective, it remains fair to hold this defendant culpable for that result, because not only are they causation in fact, not only would this not have happened but for their involvement, but it's actually not too far remote, and not and the intervening causes and what happened was entirely foreseeable. The other issue spotting measures that we're looking at, kind of two things happening at the same time, or two things happening independently, one after the other. So you see some of these fact patterns. I'm not going to go through them, but you know, D's in a fight with the victim, D1 is in a fight with the victim, and then the victim, as a result of the fight, storms across the street and is killed by a car. Okay, well, you know, D1, you might be able to make an argument is the but-for cause of that harm, because without the fight, wouldn't have stormed across the street, wouldn't have been killed. But again, the act of fighting, and it may be physical, it may be just words, it may be something that you wouldn't expect or reasonably expect would bring about death or a type of harm that's usually legislated against in a result crime. So is it foreseeable that a person could be killed in these circumstances? Is it fair to hold them culpable for the result, a person being dead, a human being being dead, just as a result of the fight? We would need more context, we would need more, more understanding, but this is what's happening. Behaving in one way, having an act, and then having a result over here, and having some defense argument that it's not fair. You can see it with the second example here. Defendant one intentionally shoots V. So, you know, we have the right mens rea going on. They actually shoot, so they have the actus rea, nicks V. But, you know, with the nick, might not have caused the social harm, might not have resulted in death or serious debilitation. D2 comes along and then kills V thereafter. So now we have, of course, a significant intervening cause, someone coming along and killing someone when they're just maybe injured. And whether it's fair, again, are they the but-for cause? Is it fair to hold them responsible as the causation, the proximate cause? And as the defense, we're really looking for the sequence of events, is there some break in the chain? Is there something unusual? Is there some superseding cause? Or is there something that comes in and happens such that we can say, hey, it's not fair to hold D1 culpable anymore because, like in the second example, D2 came along and killed this person. Maybe if they were just nicked, they wouldn't have died. Certainly guilty of something, certainly guilty of an attempt, certainly guilty of an assault with the nick, but they wouldn't be guilty of murder but for D2 coming along. That's something that breaks the chain. That's something that's superseding, at least lends itself to those arguments. I like the way that the Model Penal Code deals with these things. And, again, the Model Penal Code is just an example, but it's adopted by a number of different jurisdictions. And, you can see here it has the but-for language in there under 203.2031. And it talks about other considerations. So, the but-for result, we're talking about a result, crime would not have occurred, unless we had his act, his cause, we wouldn't have had this result. And then you see the second part here, the relationship between what he did, that actus, what this defendant did, and that result. Does it satisfy causal requirements? And you can see loosely here, but-for and then proximate cause. It's more broad, the second part, B for sure, that it's, we're talking about the proximate, any additional causal elements. But it's going to come down to a fairness determination most oftentimes. And that's what you're able to do as a criminal law student in your essays. So we read 3 cases. I think they're interesting. The first one was a Rhode Island case. It was a pedestrian death case. It has a van that knocks over a pedestrian. And we don't know at that point if hitting the pedestrian was the cause of the death or not. What we know is from that point on, the person driving the van got back in, drove away. Nobody could find the body. It turned out it was trapped underneath the car. So at the time of charging, we're not really sure, was it the initial impact that brought about the death of the person, or was it the driving away and dragging under the front of the car that brought about the death of the person? That becomes important because, remember, we always have to have some lining up. We have to have some lining up of the actus and the mens rea. You have a really good argument if we don't know. He didn't see the pedestrian, or else we might not be able to prove that he saw the pedestrian upon impact. So that's an issue. And if we can't prove that the death happened at a later time, when clearly he's now making a new decision to drive away. So the defense has some arguments here as to whether it was the but-for cause, whether that act actually caused the death in that case, in the Rose case. So it gets us thinking about when is the actual act we're talking about? Is the initial hitting someone? Well, might not have had the mens rea at that point. Or was it the driving away that did it? Well, might have had mens rea at that point, but we don't know if that was the actual cause of the death because the person could have been dead already. So there's some interesting language in the case contending that the evidence is susceptible of a finding that he was killed upon impact. He was not alive at the time, being dragged under the car. He could not be found guilty of manslaughter. So it's an interesting case, just thinking about when the defendant had the requisite mens rea, and can you connect it up to an act that actually brought about the cause. The next one was Velasquez. This is it's a kind of a drag race case. It's about 2 people drag racing, and essentially they get each other into the drag race. They both willingly participate in the drag race. The drag race is some short distance, but then after that, the other participant that's not Velasquez decides to turn around and spin around and do some different things that they do in drag races and drive off, and ends up, going and getting into an accident and plunging to his death, sort of after the race is over. And they want to hold the other participant, Velasquez, responsible, culpable for what happens, essentially, but for you getting in a drag race with this person, he wouldn't have been in drag race conditions and then wouldn't have drove off the edge and wouldn't be dead right now. So we're looking at whether it's fair. We're looking at essentially, would this have happened but for Velasquez participating in the race? And there's also, they bring up the other test of the substantial factor test that we've seen in torts as well, in addition to the but for test. But it lends itself to some arguments. The other driver kills himself. The sole basis of the defendant's guilt is just his participation in a drag race. So the idea of participation in a dangerous activity, whether that's enough to be the cause when there's these other factors. And you can see some of the language from the court. So this gives some indication as to how the court came out at the Florida court. In our judgment, it's simply unfair, it's unjust, it's just plain wrong to say defendant is criminally responsible for the death when the other driver is the one that took some independent actions, that is driving away after the race was over and killed himself. So we get some, the interceding causes, the additional causes that happen, were essentially what this person does after the race. Maybe if he had driven off the edge of the cliff and to his death during the race, we might have a different argument. And you can see what he does after here. No one forced him to whirl around, go backwards towards the canal after the race, travel 123 miles an hour, and so on. So even though the other actor is the victim themselves, it's an interesting case about whether we can hold someone responsible who is mutually engaged in a dangerous activity with the person who dies and the ultimate victim. In the last case, was a really peculiar case right out that had to do with essentially a DUI and an accident, and then essentially a car that won't start in bad weather, and he's out of the car, and then ultimately someone dies. And it's again one of these, is it fair? There's definitely superseding facts here, because we have things that happen after someone was drinking, someone was driving, those are all in the bad pile. This is a horrible facts in this case. They caused the accident, but there were intervening causes, and were they foreseeable, especially that objective standard of foreseeable? Was it foreseeable to think that the defendant's conduct would be the cause here? So it's really, this lends itself to this argument, especially a defense argument. When are the actions too remote? When is the cause? When is there not sufficient causation, sufficient connection between the action and the result, which in this case was also death, just like our previous two cases with the person getting dragged under the car and the drag racing. This person ultimately had a result crime, a murder, and a manslaughter as well. Just was it close enough to the proximate cause? So those are the things to think about when you get trying to issue spot a causation case, and also when we're reading cases, some of the types of factors and good facts, bad facts that play into the arguments, both for the government and ultimately for the defense, who are the ones raising a sort of causation issue as a possible defense.